First reading a bill for an act to restore access to the Administrative Appeals Tribunal for asylum seekers with adverse security assessments and for related purposes.
The member for Denison.
Deputy Speaker, I move that this bill be now read a second time. Deputy Speaker, the purpose of this bill is to reinstate the right of access to the Administrative Appeals Tribunal for asylum seekers with adverse security assessments. Currently, asylum seekers are denied such an appeal option due to a special carve-out for what are referred to as unauthorised maritime arrivals in the ASIO Act. Deputy Speaker, the issue here today and with this bill is not that there should not be security assessments, nor that genuine risks to Australian national security shouldn't be prevented from entering the community. Regrettably, it has been the case over years that a handful of people have attempted to enter Australia by irregular means, and they have been found genuinely to be security risks. But at the same time, Deputy Speaker, there have been people who have, in fact many people who have attempted to enter Australia through irregular means and have received an adverse security assessment from ASIO, only ultimately to have those adverse assessments overturned. They were found to be in error or for whatever reason not warranted. So the issue isn't about whether or not we should have security assessments. The issue is not whether or not there could be a very small number of people who are genuine security risks in this country. The issue today really is one about fairness and openness. And if we accept that all people are equal, and if we accept that it's a fundamental basis of our system that all people should have the right to appeal an adverse finding against them, to challenge an adverse assessment, then why on earth do we have this situation in Australia, Deputy Speaker, where an Australian citizen who receives an adverse security assessment is entitled to make an appeal to the Administrative Appeals Tribunal, but an asylum seeker is not? The bottom line is that in our law, an asylum seeker is regarded as a second-class human being that somehow is inferior and should have less rights than an Australian citizen. And that's wrong, Deputy Speaker, and this bill would remedy that by removing that carve-out from asylum seekers from the relevant part of the ASIO Act. The situation we have at the moment where asylum seekers do not have the right to appeal to the Administrative Appeals Tribunal clearly puts us at odds again with our responsibilities under international law. It clearly contravenes, among other things, the International Covenant on Civil and Political Rights. And, Deputy Speaker, if I can just refer to 4 particular sections. Article 9.1 says that, this is of the International Covenant on Civil and Political Rights, says that no one shall be subject to arbitrary detention. But the problem with Australian law currently is that for detention not to be arbitrary, people must be sufficiently informed of the reasons for it, and there must be individualised consideration of its necessity and whether less restrictive options might be available. There also needs to be a legal right to seek effective review of the reasons for detention and the security assessment underpinning it. But Australian law contains none of these safeguards. Deputy Speaker, Article 9.2 goes on to say that anyone who is arrested shall be informed at the time of arrest of the reasons for their arrest. But in Australian law, this right extends to non-criminal arrest and detention, and it will be violated when this is in Australian law. What I'm doing is explaining the out of the convention that this right extends to non-criminal arrest and detention, and it will be violated when people are not adequately informed of the basis for the security assessments underpinning their detention. But again, and this is where I get to Australian law, contains nothing to prevent such violations from occurring. Deputy Speaker, the Convention says in Article 9.4 that anyone who is deprived of their liberty shall be entitled to take proceedings before a court. They need to be able to challenge a loss of liberty on the basis that it is arbitrary, unnecessary and disproportionate. And again, this option is not effectively the case in Australian law so long as the carve-out exists in the ASIO Act in regard to asylum seekers. Articles 7 and 10.1 say that no one shall be subject to cruel, inhuman or degrading treatment, and all persons deprived of their liberty shall be treated with humanity and respect for the inherent dignity of the human person. And it goes on. So my concern here, Deputy Speaker, is that the current arrangement where asylum seekers are denied appeal to the Administrative Appeals Tribunal clearly puts Australia at odds with our obligation and as a signatory of the International Covenant on Civil and Political Rights. And it's not just international law where we are erring. Even Australia's Human Rights Commissioner has made comment about this, Deputy Speaker. And in 2013, Professor Gillian Trigg said that she strongly supports extending the rights to merits review in the Administrative Appeals Tribunal to refugees who have received an adverse security assessment. Now, the government might say to me that I'm on the wrong track, that in fact the so-called Stone Review is a mechanism which does give asylum seekers with adverse security assessments a proper avenue for appealing that adverse assessment. But look, as welcome as the establishment of the Stone Review was and is, it is still an inadequate mechanism for asylum seekers with adverse security assessments to make their case again. Because quite frankly, Deputy Speaker, the Stone Review while it does provide some limited oversight and review of adverse security assessments, and it is something to build on, it doesn't cure the process of its fundamental shortcomings in law. The Stone Review, for instance, is a non-legislative process operating solely as a matter of policy, and it can be discontinued on a whim. Individuals have no legal right to petition for a review by the Stone Review. So in a sense, it's not actually a right of appeal. It's at the whim of whoever's running the review at the time. And the outcomes of the independent review are not binding. It doesn't produce decisions, it produces opinions and basically requests people to abide by them. Now, the government might also say, "Oh well, but there are limitations with the Refugee Convention, so it needs to make these changes in Australian law." But that's not the case either, Deputy Speaker, because in fact the Refugee Convention recognises the legitimate interests of governments taking steps to protect national security and the safety of citizens. In fact, Article 1F of the Refugee Convention sets out the grounds on which people can be excluded from international refugee protection on the basis of serious criminal activity, things like war crimes and crimes against humanity. Article 32 allows refugees to be expelled where they've been deemed to pose a risk to national security or public order. Article 33 of the Refugee Convention prevents refugees who pose a serious danger to national security or the community from relying on non-refoulement protection. So what do we have to fear from giving these people a right of appeal to the Administrative Appeals Tribunal? Nothing. Nothing at all. Because let them appeal. And we're not talking a lot of people here, Deputy Speaker. We're only talking, perhaps a few dozen in detention at any one time in Australia who are in indefinite mandatory detention on account of an adverse security finding. What do we have to fear from these people? Because if they make their appeal and the original security assessment is upheld, then Australia is quite within our rights as a signatory to the Refugee Convention to prohibit those people entering the community. I suggest, Deputy Speaker, the problem here is that this is another punitive measure by a cruel government which has a cruel policy. That's the bottom line here. It's punitive. It's another way of saying to those millions of displaced people and people on the move around the world that we're a tough country and we're going to be tough on you and you better not try and come our way. It's a punitive and cruel measure. It is not the sort of measure that a sophisticated and civilised country like Australia should be allowing. I make the point again, I must have said it 100 times in this place, Deputy Speaker, until Australia starts acting like a rich and civilised country and honouring the spirit and word of the Refugee Convention, then we are going to have a terribly black mark against our name. I'd like to thank the Australian Churches Refugee Task Force for helping me develop this bill, and also the Human Rights Law Centre in Melbourne, both of whom have been very, very helpful, and both of whom are very exercised about this matter, who are firmly of the view that it is quite improper to continue denying asylum seekers access to the Administrative Appeals Tribunal. Deputy Speaker, I commend the bill to the House.
Thank the member for Denison. Is the motion seconded?
Mr Deputy Speaker, I reserve my right to speak